So to put sort of a bookend on this, was we've dealt with this very explicitly up to this point, and that is the different forms of speech. I normally would have done this before, but I like to do it at the end of this is because you've encountered very different types of speech, and now I want to define how to think about that. We obviously know that the one that's not listed up here is pure speech. Pure speech is what I'm doing right now, advocating in an oral fashion. That's pure speech. There's no question that the First Amendment applies to this type of speech. The next two types of speech that we should probably discuss are symbolic speech. Symbolic speech of the type that exists within Cohen v. California, the type that exists within Tinker v. Des Moines, in which there is absolutely no oral communication whatsoever, but a message is clearly being communicated to almost every observer. And also, if it's political, it's going to have protections to the same degree as oral speech. What is different, however, in terms of categorization is speech plus. You're going to ask what the plus is. Well, the plus is action. So it's speech and conduct. So the speech in and of itself might not be problematic. And the speech itself might be protected, but the conduct is not protected. Now, there are certain examples where the speech and the conduct are simultaneously protected because the conduct is part of the speech. But conduct generally in and of itself, an action, does not rise to the same height of protections as symbolic speech or pure speech, because the engaging of actions might actually violate other laws. And since the First Amendment is clear in terms of speech protections, we distinguish between speech plus and pure speech. And we distinguish between symbolic speech and pure speech dependent upon whether it's political or not. So symbolic speech that isn't political doesn't rise to nearly the same level of protection as symbolic speech that is political. What kind of conduct would be protected? Literally the next case. So you burn an American flag, that's conduct. You've done an action, but it's protected conduct because it is so overtly political, that the conduct itself is almost speech. So what other types of conduct would engage in speech? So let's take graffiti for an example. Graffiti is an example of conduct that is also speech. So let's say you kneeling. Yeah, but the government has never put a kibosh on kneeling. This is where we run into the difficult problem. It's like there's lots of conduct that is speech, but the government hasn't tried to stop it. Like the president saying that those individuals who kneel during the national anthem are traitors or whatever. Well, he didn't stop them. He just said it. So whatever. They can still kneel. You can still take a knee during the national anthem. How about not playing the national anthem? I mean, not that is, I don't know how much you all follow politics, and I hope the answer is less than I do. But the Dallas Mavericks are debating no longer playing the national anthem before their games.
Yeah, I heard he went ahead and he's going with that.
Yeah, and in response, Ken Paxton, your not lieutenant of government, attorney general. No, Ken Paxton is, I don't know, some crazy in Texas government. Dan Patrick, that's the one I was thinking of. Dan Patrick, not Ken Paxton. Dan Patrick is proposing a law which is so poorly written that it'll get thrown out immediately. But the law is that you'll be required to play the national anthem before any publicly supported event. So any event that gets public funding will have to play the national anthem. The last I checked, this event right here is a publicly funded event. So do I have to play the national anthem before I start teaching class? Like, I mean, okay, sure, I will, but that's dumb. And feel free to take a knee during it too. Like, there's just the law itself in question, which obviously hasn't been passed, is just, it's so overbroad. Like, he's trying to target sporting events, sure, but by it's written, any publicly supported event would have to play the national anthem. That's just, it's absurd. Like, do the vaccine handouts have to have the national anthem before they start? Like, what? I already think Texas is crazy since you have a fucking pledge to the Texas state flag. Like, that shit is absurd. You all, the state of Texas is crazy. But mandating the national anthem is just a bridge too far. So that would, all of those sorts of things. So yeah, vandalism. It's very, very political, especially let's say even the message of what you vandalize. The message itself is political. And I wasn't even going the statue route. The statue route is a good example. Let's say and I'll use North Carolina as an example. The University of, in fact. So the University of North Carolina had a statute at its gates, and I say had because it was very recently taken down. I can't remember the name of the statute. It's escaping me right now. But it was a statute dedicated to Confederate veterans. And it was at the gate of UNC. And it had become part of campus tradition and lore and everything else. But there's no escaping the fact that it was a Confederate veteran dedication. And that even at the presentation and swearing in of this statue, it was, yes, Silent Sam, thank you. That it was very clear that the Silent Sam was put there for racist intent. Literally the people that donated and spoke about the installation of Silent Sam made it very clear that this was, it was for racial purposes. Well, let me give you an example of protected versus not protected. Protected would be not necessarily directly vandalizing the statue, but covering the statue, an example for blood that can be cleaned off. That's protected speech. It's vandalization, but it's not permanent vandalization. Or draping cloth around the statue. That has a political connotation. Anything like that doesn't permanently damage the statue. But tearing the statue down, while clearly overtly political, is conduct too far. Because you've actually engaged in damaging of private property at that point, or public property. And that's really what sort of it hinges on, is damaging of property. So if you have a way to vandalize in a political fashion, which is not damaging, go for it. My recommendation, chalk. Because chalk fucking washes off. But that's probably the easiest one to think of, is vandalization of public property is conduct, even if it has an overt political message, if the conduct is sort of a permanent or existing damage. Yeah. So speech plus is much less protected unless it isn't, especially if it's permanent. But like the burning of an American flag, as we'll see in the next case, it's very clearly speech plus. It's not a passive activity. So for example, wearing an armband is passive. You put it on, it's just there. It's a passive activity. Wearing a jacket that says fuck the draft, passive activity. Burning an American flag is an active activity. It's not passive. You're actively doing it. The action of doing it is the speech. And that's different in some important ways. So if it's not clear, that's fine. It shouldn't be clear. I want you to know the distinctions, but if there isn't like a bright line, this is A and this is B. They are kind of fungible. And that's why the court still has to regularly weigh in on these issues, is because new things come up that aren't, settled points of law, and they have to figure it out. And so similarly, you all should be not clear on what these separations and differences are. All right, we're going to move on. So, Texas v. Johnson. Let me get to this point in my notes, just so I can get it all right, because, we should. All right, so Texas v. Johnson. Case happens in 1989. It's a very sharply divided decision. Could not be a more political decision that the court reaches, but because of the ideological mix of the majority opinion, it's held on as good law. So what are the facts behind this case? So Johnson, in this case, was convicted of burning a flag in front of the City Hall in Dallas, Texas, when Dallas, Texas was holding the 1984 Republican National Convention. And Texas law, because of course it does, prohibited the desecration of the flag. His conviction was based solely on his action, because he didn't say any words during the demonstration, or at the very least, no one heard any words uttered through the demonstration. And so the conviction of desecration of the flag wasn't based on anything orally he said. It was solely on the action he undertook, solely upon that conduct as speech. So the issue in this case, very much more to the point than the other sort of extrapolations that we've done, is burning the American flag political speech protected by the First Amendment. And the Supreme Court says that, yes, this is protected speech. Justice Brennan argues or writes the majority opinion in this case. He says that the government has a freer hand in restricting expressive conduct than it does in restricting the written or spoken word. It may not, however, prescribe particular conduct because it has expressive elements. So basically, he says that this is clearly expression. Expression is clearly different than written or spoken word. But in this case, the meaning of the action was so overly political and so obvious to any observer that the action itself was political in nature. Brennan says if there is any bedrock principle underlying the First Amendment, it is the idea that the government may not prohibit the expression of an idea simply because society finds that idea offensive or disagreeable. We are tempted to say that the flag's deservedly cherished place in our community will be strengthened, not weakened by our holding today. Our decision is a reaffirmation of the principles of freedom and inclusiveness that the flag best reflects, and of the conviction that our tolerance of criticism is a sign and source of our strength. So the majority strongly articulates this position that the flag is a very special part of our identity. But because of that, protecting against its desecration is also a very strong part of our national identity. And so the reason why this case was so sharply divided, the reason why the action undertaken of burning a flag is so divisive is precisely because it's a very strong and effective means of speech. It's very clear when you burn the flag to any observer what message it is that you're communicating. And it is, by its essence, an overt political messaging. Because of that, the First Amendment has to protect in this regard, because the burning of a flag is a critique on American government and the American system or the American society at that time. And that's precisely the part of speech that the First Amendment exists to protect. And so even though this is a cherished artifact and symbol of the nation, and perhaps even because of that, the majority says that its protection through flag desecration laws is a violation of the First Amendment. There are two primary dissents that I want to focus on. Just ignore the concurrences. I don't really care so much. So there's two primary dissents. And the first one that we're going to cover is Justice Rehnquist, Wright, and O'Connor's dissent. And so what they say is that Johnson was free to make any verbal denunciation of the flag that he cared to, and that even in private, he could have absolutely burned the flag as well. But the burning of the flag is conduct. While it is symbolic expression, it's conduct, and conduct by its very nature is not protected. So burn the flag in private, that's protected. It's in private. Verbally denounce the flag and the GOP and the federal government and anything else, and all of that's protected. But the point at which you engage in conduct is not protected. And this action, the burning of the flag, is very clearly conduct, so much so that the majority spends a fair amount of time discussing how this conduct is actually speech. But it's been a long holding of this court is that conduct is different, and this action is also conduct. It's undeniably conduct, and therefore they would not strike down the Texas law on this question. The one last dissent is an important one that I want to focus on for a few reasons, and that's Justice Stevens' dissent. Justice Stevens says that the flag's value in and of itself as an item cannot be measured, and that Johnson's act in burning the flag involves disagreeable conduct that, in Stevens' opinion, diminishes the value of an important national asset. There's one thing to know about Stevens, who at this time was the most liberal member of the court. This would be, for example, Justice Souter right now dissenting in a case in which the rest of the other liberals were in majority. It's an oddity. Justice Stevens has one thing that those other liberals don't, and Justice Stevens had a storied and well-documented military career of service. And Stevens is very much writing, and is after he left the court, had very much articulated that part of his decision-making in this case was very much related to his history of military service and his understanding of military service. And so I kind of want to bring this to the modern context in the questions we've talked about kneeling, and we've talked about other sorts of issues that involve patriotism and respect for the flag. And in the current context that we're in, all of that has become very starkly partisan. That if you see someone kneeling for the flag, and you disagree with that, you are automatically, and perhaps correctly in our environment, identified as being more conservative and more Republican. And if you look at someone who's kneeling and you identify with them and want to protect their right, you're identified as liberal or Democrat. And this case really isn't that long ago. I mean, it's long ago for all of you, not long ago for me. And in this case, it's very clear that opposition to kneeling, or that opposition to flag burning, or that opposition to anything that's anti-patriotic isn't neatly an ideological thing. And there's nothing more clear than Justice Stevens, the most liberal member of the court at this time, dissenting because he feels that burning of the flag in a political protest damages the value of the nation itself. So a liberal member having a very patriotic response to an action should be a reminder to us that ideology doesn't have a particular claim to what is patriotic and how to be a patriot. That's something that is very much immune to ideological persuasion. And Justice Stevens reminds us that even though I disagree personally with his decision here, we should not forget the fact that it's primarily his military service that makes this decision, and not the fact that he's liberal. Though being a liberal who supports patriotism is absolutely as possible as being a conservative who supports patriotism. There exists nuance in this world, in this political world, despite the fact that we like to compartmentalize things into left and right, and yes and no in these neat little boxes. The world is much more complex than